Welcome to meeting number 26 of the House of Commons Standing Committee on Human Resources, Skills, Social Development, and the Status of Persons with Disabilities. Today's meeting is taking place in a hybrid format, and I believe all participants are appearing virtually. Am I correct, Madam Clerk? At least members are, so we will follow whatever health protocols are required. I want to advise committee members that you have the option of speaking in the official language of your choice. And if we have a loss of interpretation services, please get my attention by signaling me with the raised hand icon, and we will suspend the meeting while we correct whatever issues they are. I would also want to remind all participants to address their questions through me, the chair. And please identify who you will be questioning. As you know, today, pursuant to Standing Order 1082 and the motion adopted by this committee on Monday, May the 16th, the committee will commence its study on the subject matter of Part 5, Division 26, 27, 29, and 32 of Bill C-19, an act to implement certain provisions of the budget tabled in Parliament on April the 7th, 2022, and other measures. And this is a subject matter. It is not a clause-by-clause review of these sections. I would like to welcome our witnesses from the Department of Employment and Social Development, and bear with me if I make a few errors, but we have Anna Casey, Director General, Employment Insurance Benefits, Processing Benefits, and Integrated Services Branch. Ruba Dabusi, Director General, Benefits and Integrated Services Branch. Sajid Dean, Director General, Employment Program Policy and Design, Skills and Employment Branch. Zia Prulu, Director General, Strategic Policy and Analyst and Workplace Information Directorate. Anika Mona Nandi, Acting Director General, Employment Insurance, Skills and Employment Branch. George Ray, Acting Executive Director, Strategic Policy and Legislative Reform. James Scott Patterson, Acting Director, Benefits and Integrated Services Branch, and Farid Saeed, Director, Employment Program Policy and Design, Skills and Employment Branch. I'm going to ask at this time if and which one of the witnesses are going to give an opening statement. We have anybody from the, if there is no opening statement from any of the witnesses that are appearing, am I correct on that, Madam Clerk?
There is no opening statement, Mr. Chair.
Okay, then I will go directly to questioning of the witnesses. And to begin, I will go to Madame Kuzi for 6 minutes. Madame Kuzi, you have the floor.
Thanks to the witnesses for being here today. Ms. Casey, a change in Clause 26 is the eligibility to qualify for EI. Previously, the requirement was an individual who paid into the program for at least 5 of the last 10 years, was changed only 3 of the last 10 years. Why does the department want to make the change from 3 years from 5 years?
Hi, my name is Sajid Dean. I'm the Director General in the Skills and Employment Branch, responsible for these changes to the Employment Insurance Act. As outlined in Budget 2022, these changes are being proposed to broaden eligibility for skills and employment training under EI Part 2 of the Act. So previously, for an individual to receive intensive training supports under EI Part 2, you would have had to make either be an individual who was in receipt of employment insurance benefits, someone who had received benefits in the last 5 years, or you would have had to make a minimum level pay a minimum level of premiums in 5 of the last 10 years. And so this change is being proposed to reach those individuals who are further removed from the labor market, who have made contributions
that's clear now, Ms. Bean. Thank you.
Thank you.
Do we know what financial impact these changes will have on the EI fund, Ms. Dean?
So these changes will only be in effect once new agreements are negotiated with provinces and territories. As outlined in Budget 22, the government signaled its intent to negotiate new agreements. So at this time, the existing provisions of the EI Act will continue until such time that new agreements are in place. Thank you.
Okay, and we won't know the financial impacts until the new agreements are in place, it sounds like. Thank you.
Thank you.
Can you provide an overview to the committee on the consultation process regarding the changes set out in Division 26? What consultation process took place regarding the changes in Division 26, please?
Absolutely. So extensive consultations took place in 2016 and 2017. About 700 labor market stakeholders took part in those consultations across Canada, and these are also being proposed due to ongoing consultations with provinces and territories who currently implement 13 sets of, there are bilateral labor market transfers with each of the provinces and territories. And so as part of the ongoing implementation of those agreements that serve about 1 million Canadians a year, we have heard from labor market stakeholders that there is a need to reach those that are further removed from the labor market.
Okay, I'm going to move to Division 32 now. Why did the government decide to create a new body, the Employment Insurance Appeal Board, to deal with appeals?
Sorry, can you hear me?
Yes, I can, Ms. Debussy. Thank you.
Okay, so in 2012, the SST was the former tribunal was dissolved and created an SST. And following that, in 2017, there was a review of the SST, and a decision was made that there is a need to improve the tribunal to make the first level of hearing easier to navigate and more responsive to the needs of Canadians, and to eliminate legalistic approach to those hearings.
And can you provide an overview as to the consultation process taken regarding the creation of the new Employment Insurance Appeal Board?
I'll turn that to my colleague, Scott Patterson.
Hi, thanks very much. While I don't have a list here of all of the consultations that were done, there were a number of consultations that were done during the third-party review and following that. If you would like a list of those, we can provide them.
If you could provide that to the committee, that would be helpful. Table that to the committee, Mr. Patterson. Thank you.
Will do.
Excellent. Why couldn't appeals be successfully dealt with through the Employment Insurance Appeal Board? Maybe I'll go back to Ms. Debussy for that response, please.
Yeah. So the current appeal board has one panel, and one of the big concerns that we heard through the consultation and the review was the need to have a tripartite model, one that would represent the commission, one that would represent employers, and another that would represent employees. That's one of the biggest drive behind the creation of the new Board of Appeal.
10 seconds.
Yep, certainly. What kind of new supports does the department intend to provide through these new measures in Division 26, please, going back to that?
Sorry, the time is out. You'll have to answer that question at another session.
Okay, thank you very much, Chair, and thank you to the witnesses.
We'll move to Mr. Long for 6 minutes. Mr. Long.
Well, thank you, Mr. Chair, and good afternoon to my colleagues, and thank you to all the witnesses that are on the on my screen here this afternoon. Thanks for what you do for our country. My questions will be to the appropriate person. I'm not sure who would answer, but my first question, I got a few comments. I'm going to ask some questions on Division 27, which is extending the temporary measures for seasonal claimants, like obviously from October 30th, 2022 to October 28th, 2023. I mean, look, we certainly realize, the pandemic has exposed the need for modernized employment insurance. I think we all have seen that in our riding, how it did expose weaknesses in the program. And we do need a EI program that aligns with the realities of today's labor market and is capable of quickly responding to changes in the economy, like we just seen obviously in the pandemic. To inform long-term development of a plan for future of EI, Budget 2022 reiterated the government's commitment to continue consultations with Canadians on what needs to be done in the EI program to meet the current and future needs of workers and employees. The temporary nature of the proposed one-year extension to the support measures for workers in seasonal industries provides the flexibility to complete consultations before implementing a permanent approach for this important group of workers. And I mean, look, as a sitting government member, we certainly recognize that employment is seasonal, like especially in seasonal industries. I can name many, whether it's tourism or fishing or what have you. It's an important part of Canada's continued prosperity. And certainly, the temporary measures to support workers in seasonal industries ends in the EI Act on October 29th, 22. The proposed amendments would extend the current legislative provisions for 1 year until October 28th, 2023. So, this will enable eligible workers in the 13 targeted EI regions currently covered by the temporary measure with highly seasonal economies, including workers in the seasonal industries whose seasonal claiming pattern was disrupted by the timing of temporary COVID measures, to continue to access up to 5 additional weeks of EI regular benefits in their off season. So the questions I have, and again, whoever appropriately can answer, please do. What are the biggest gaps and issues with EI that you discovered due to the pandemic? And what lessons have been learned for improving EI specifically as we are focused on modernization? Thank you.
Thank you for the question, Chair. So I can begin to answer that question. So in terms of the biggest gaps in terms of EI modernization, I think the consultations are ongoing, as you may know. So we've had phase 1 of the consultations from August 2021 to February 2022. We are currently in phase 2 that will extend from April of this year to July of this year, and so I think the in terms of the lessons learned from those consultations and even from the pandemic, it will be as part of the consultations that we will get that future evidence from stakeholders, but certainly one of the areas or some of the areas that were notable during the pandemic in terms of gaps were in terms of access to the EI program, in terms of eligibility, adequacy of EI benefits, supports for seasonal workers, supports for the self-employed, and hence those are key topics for some of the key topics for the current and ongoing EI consultations.
Well, thank you for that. I guess the question is, why did the department, or why did you not continue with previous temporary measures introduced in Budget 2021?
So thank you for that question, Chair. So in terms of the previous temporary measures introduced in Budget 2021. At the start of the pandemic, the government responded rapidly by introducing temporary and emergency income support measures that ensured that people could continue to make ends meet, even as the pandemic prevented them from working. And then following this and recognizing that many workers were impacted by the COVID-19 pandemic, lost their jobs, or worked reduced hours, a set of temporary measures were introduced through that Budget 2021, to facilitate and maintain access to EI as the economy recovered. And so there were a number of temporary measures that were introduced in Budget 2021, including certain common entrance requirements and EI simplification measures. And these temporary measures facilitated greater access to a more simplified EI program during the pandemic and subsequent waves of unemployment. However, as Canada's economy continues to recover from COVID-19, the lessons learned from those temporary measures, as well as from the pandemic and ongoing consultations, will inform the long-term plan to modernize the EI program.
Thank you.
Thank you so much for those answers. And again, thank you for everything you do for all Canadians. And over to you, Chair. Thank you.
Thank you, Mr. Long. Madame Chabot pour 6.
Madame Chabot, you have 6 minutes. Thank you, Mr. Chair. Thank you to the witnesses for being here to answer our questions. Well, I would say that things are a little bit foggy here, and it was foggy this weekend, and we have the same fogginess here with employment insurance reform. So I think that we've seen that we're going to be needing to wait longer, although there are solutions that are well known. So why within this bill, for seasonal workers, once again, you're extending without improvements the seasonal workers pilot project. So why did you not try to improve those programs? Because obviously the 5 weeks is not sufficient.
Thank you, Chair, for that question. So as I mentioned, the consultations are ongoing. Those consultations will continue to inform the government's work on EI modernization. And once those consultations are complete, including on the very important topic of supports for seasonal workers and the development of a permanent measure to support this important group of workers, that will move forward as part of the long-term modernization considerations and the content of that.
So the number of hours, those measures that are coming to an end in the fall, why have you not adjusted it in the same fashion?
There was a decision in Budget 2022 to provide for a 1-year extension for workers in seasonal industries to support this important group of workers. And at the same time, those other temporary measures are in effect.
Well, we see that's not sufficient. I'm going to move to another question with respect to Division 32. You are telling us that there is a reform coming for the employment insurance, and there have been many concerns. Why did you not take these concerns with respect to the tribunal and look at the reform in that section? Now we're seeing in an omnibus bill where there's more than 400 pages, we see a section with respect to the appeal board, and that the only change is the name, because it really doesn't respond to the objectives and the commitments that the government made in 2019. So how did you come to be proposing this now? And to our knowledge, there really hasn't been any consultation with the main groups concerned. In fact, there's unanimous opposition. So what motivated you to include that in Bill C-19, this new Employment Insurance Board of Appeal that doesn't respond to the government's promises in 2019? Well, with respect to the context within the 2019 budget, the government made a commitment to make the recourse for employment insurance appeals, make it more easier, more adapted to the needs of Canadians, as well as setting up a tripartite model to ensure that decisions taken would really help represent the groups that are concerned. Well, the group concerns would like to have a time for consultation because the formula, as you say, with respect, does not allow for a simplification, but rather it creates inequalities, and it doesn't really give any real capacity for the beneficiaries to be heard, because it's a regional model, and so there's different questions. There's groups that are asking that it be removed from the bill so that it can be treated separately. Are you open to taking this section out of the bill, that we give it a real study and give it the attention it needs? Answer. Well, there was a lot of consultation that brought us to this point, and we have given the information on consultations, and I can tell you that the model that we have established and that the government has promised responds exactly to the needs that have been identified during consultations, including the regional model. So we have members who represent each of the regions. We are going to have roughly 100 members from each group, and so both the employers and the employees all across Canada will be represented. Thank you. Thank you, Madame Chabot. And now we're going to Mr. Bulleris for 6 minutes. Thank you very much, Mr. Chair. Thank you to all of you for being here. I hope you're able to hear me well. I'm also going to take the time that I have to talk about employment insurance, and there's something that is very troubling, and I wanted to explain to you the reality that exists and what people are telling us in our riding offices. Last January, there were delays that weren't respected, and there were 300,000 problems, and the delays were 3 to 4 months. Some people hadn't received any answers after 5 months, even after 7 months, and they stayed without a check. They were waiting for answers from employment insurance. So earlier you opened the door somewhat when you said that because of the crisis we set aside temporary measures because we want to help people pay their bills. How do you think people can pay their bills when the system that's set up has 3, 4, 5 months of delays? How can people pay their bills? Thank you very much, Mr. Bulleris.
Benefit processing. We have dealt with unusual volume increases of EI claims over the last year, in large part because of the pandemic of Omicron. And we also have seasonal peaks that does give us peaks and valleys in how we receive claims. That being said, we do have been able to process payments meeting and exceeding our service standard of being able to pay claimants within 28 days, 80% of the time. For last fiscal year, our service standard was met of 85.4%, which is exceeding our service standard and is the highest result in the last 15 years if we exclude the period of COVID-19. The majority of our claims are processed within 2 weeks for those that are beyond the 28-day service standard. So 14.6 of these that are the remaining of the claims are processed within 2 weeks. For last fiscal year in 21-22, fewer clients waited beyond 28 days to receive their benefits. The average days it took for clients to receive EI payments is 18 days. And again, excluding the COVID-19 period, this is the best result since tracking began over 13 years ago. So,
oui, peut-être que.
Well, maybe the 13 previous years weren't necessarily glorious. So for people that aren't receiving their checks, even if they're only within the 20%, it's unfortunate, but it is a reality that these people have to borrow money from family and friends or take on loans and pay interest on that. And this is really terrible. These are desperate people that are coming into our offices. So I hope that things will continue to improve. With respect to the Employment Insurance Board of Appeal, Madame Debussy, will you be able to send to the committee the list of the groups and organizations with whom you consulted to create this Board of Appeal? Yes, absolutely. That was it. That was the question I had. Why is it that within this Employment Insurance Board of Appeal, there are people that represent the government there full-times, but the union representatives and the employer representatives are only there part-time? My colleague Chabot said that this you're talking about a tripartite process, but it doesn't look equal. Maybe I could clarify. Yes, the model was to have members from who would be part-time from all sides. The difference between the two is that the director, who is responsible for the tribunal, this is a full-time position, as well as 6 full-time positions that are 4 coordinator positions, and those also are full-time positions. The rest are on the part-time model, except that we wanted to ensure that members who are now part of the SST and that their mandate is not finished until the time of the new board, that those people would have positions that could continue on so that they can continue to offer their knowledge and experience. And so those are temporary measures. Okay, thank you very much for that. With respect to the person who is going ahead with an appeal, will that person have in-person hearings, and will they be able to do that in the regions, or will it be centralized and that they're not able to go in person? If they can't go in person and if they don't have to pay to travel, that's very important. With
the both options.
Thank you. Merci, Monsieur Bulleris.
Thank you, Mr. Bulleris.
Mr. Ruff for 5 minutes. Mr.
Thanks,
Ruff?
Chair. Can you hear me all right?
Yes.
Perfect. So my first question will go back to build off MP Cusey's earlier question around Division 26 and the answer talking about the negotiation with the provinces that need to happen in the timeline. Do you think that, for the witnesses, do you think that's actually going to happen in this budget year, that those negotiations will be complete?
Well, the budget does signal that. Let me just pull up the exact language now. That that the government signals its intent to intensify discussions with provinces and territories. So it says over the coming year. So that's the the direction we have out of budget 22. So it's certainly our hope for that to take place.
So,
Thank
all
you.
right. So if I understand that, you're going to, they're hoping that the negotiation will intensify and it'll get done before in this budget year. Gotcha. Next question is around Division 29. According to the Legislative Employment Equity Program, the government does not keep record of federal companies with less than 100 employees. Is that correct?
I'm sorry, this is Zia Pu from the Labor Program, but I'm not sure I'm not sure I understand the question related to Division 29.
So does the Legislative Employment Equity Program, does it keep records for of companies with less than 100 employees?
I may turn it to my colleague Douglas Wolf, who may have an answer on this one, because this is not in the proposed changes included in Division 29.
Yes, thank you. I can respond to this question. So yes, in terms of the employment equity program, normally it would apply to companies that are 100 employees and over.
So does the legislation apply to them or not then for those employers that have less than 100 employees?
So as of December 1st, the legislation will apply to all employers within the federally regulated jurisdiction.
All right, so it will if they're under federal jurisdiction, even if they have less than 100 employees. Perfect. Thank you.
That's correct.
According to the bill, in some skilled trades, in employees in those skilled trades, they work for more than one employer if they have different contracts. In situation when a worker has multiple employees, how will this bill provide paid medical leave for their workers?
Well, one of the changes that we did included in C19 is to make sure that employees who their employers change as a result of a transfer of business or contract retendering process would not lose their earned days as paid sick leave during the year if they're working for the same job. So that's one of the changes that was made in BIA1, that's proposed in BIA1, which was not proposed in the original Bill C3, which received royal assent in December.
So how, again, I don't know if that really answers the question. How are those people, so who's sort of responsible then for that paid medical leave if they're doing it for multiple different, is it whoever they earn that time with the first contract and then once they get to the second or third, like I guess, can anybody provide clarity on that?
So if they're doing the same job and it's a result of a transfer or contract retendering process, then the new employer would be responsible for their paid sick leave.
Super. I guess my final question will be to likely multiple officials, but it's just a respect to each division that we're here discussing today. What do you think, in with respect to each division, is the greatest risk to the changes that are being proposed with C19?
Mr. Rupp, do you want to identify somebody?
Well, I said, so whoever's the official the best suited to reply to Division 26 and then Division 27, 29, and 32.
Okay, a question has been put. Who's going to answer it?
I'm so sorry, my audio cut out there on the question on section 26.
Mr. Rupp, repeat it again and I will extend your time.
Thanks, Chair. So my question was, for each division, what do you think the greatest risk is with the changes that are being proposed in Bill C19? So just what are the risks associated with these changes?
What is the risk? Well, for the Section 26 changes, I guess I can speak more generally. We propose these changes in anticipation, based on all of the data and the information we have right now. What we have right now, the context we're in a situation of labor shortages. So what we're trying to do for the changes in Section 26 is to reach those who are furthest removed from the labor market. So I think, as we've seen how the pandemic has been unfolding, the biggest risk is that another shock or another change were to occur. And then we would have to go back and see how to address that. So I think, particularly for the changes on Section 26, we hope that our projections and the changes we're introducing will have the impact that we hope for. But again, the labor market is such right now that there's that much unpredictability that we can't be sure. So I think that's the risk I would flag for the changes on Section 26. Thank you.
Thank you. Thank you, Mr. Ruff. We'll now move to Mr. Van Bynen for 5 minutes.
Thank you, Mr. Chair, and I want to thank all the witnesses for participating in the discussion today. This question could be directed to Ms. Casey or Mr. Busey. We've committed to enhancing our employment insurance system for the 21st century, and we've paired these commitments with programs for employees to acquire skills and best practices that fit our labor markets. I'd be interested in knowing why, despite these programs and those offered during COVID-19 pandemic, a modernization is necessary in your opinion. Ms. Casey?
Hi, I can take that question. Thank you for the question. So in terms of modernization, the EI program has not been reformed as a whole. Although there have been numerous improvements made to the program over the years, it hasn't been reformed as a whole for the multiple decades. And as such, it is important, and it is clearly something that we have heard from stakeholders during phase 1 of the consultations, that the program is in need of comprehensive reform. Hence, the continuing consultations on EI to inform the government's long-term plan on EI modernization.
Okay, so as a follow-up question, how would these changes that are being proposed affect the programming currently under EI Part 2, and why is it a good idea to broaden eligibility?
So for that question, I will turn to my colleague who leads on EI Part 2 to respond.
Hi, thank you very much for the question. So the changes to EI Part 2, we know because we are reducing the amount of time that you would have had to pay premiums in the past. Like I mentioned earlier, currently in the EI Act, you can be eligible for extensive training if you are in receipt of EI benefits at that point in time, if you've claimed EI in the last 5 years, and if you've contributed premiums in 5 of the last 10 years. So by reducing that bar for premiums paid, we will be reaching more individuals. And the goal, like I said, is to reach those who have weaker labor force attachment. Thank you.
Okay, thank you. Now, with respect to Division 27, I'm wondering what monies on separations are, and what was the monies on separation temporary measure announced in Budget 2021, and why is a transitional amendment needed for monies on separation with as a temporary measure?
Thank you for those questions. I'm happy to provide the answers. So in terms of what is monies on separation, it's the money that is paid to an employee following separation from their employment. It can include things like severance pay or accumulated vacation pay that is paid out to the employee upon their job separation. And under pre-pandemic EI rules, those monies paid to a claimant following their job separation were allocated as earnings. And that led to payments of EI benefits to a claimant not starting until after their separation monies were exhausted. So what that means is that in cases in the pre-pandemic context where a claimant began to receive EI benefits before they receive a separation payment, and the employer did not indicate that on the initial record of employment, an overpayment of EI benefits could result, and then the claimant would need to return the amount of overpayment. So that's what monies on separation is. And then to continue, in terms of the second question, what was the temporary measure on monies and separation announced in budget? So what that measure was is that it was a one-year temporary measure that was implemented as of September 26, 2021, and it was to support workers to receive their monies on separation. Again, that vacation pay, that separation pay, to receive it sooner. And so they could get their EI regular or special benefits as soon as possible at the same time as having that monies on separation. And this temporary measure also applied to self-employed workers who had entered into an agreement with the Commission to receive special benefits coverage.
Thank you. Thank you, Mr. Van Bynen. Madame Chabot, pour 2 points.
Madame Chabot, you have 2.5 minutes.
I'm not hearing Madame Chabot.
Okay.
I'm sorry, I had my microphone up on the top of my head. Can you hear me now? Yes. To hear you say, we hear your answers on Division 32 that it responds to needs, but this is not really the situation. There's a lot of representation, both from the union side, from the unemployed, even from the employers. Everybody was surprised to see this section within Bill C-19 because everyone would like to see consultations to be able to discuss the issue so that it really can reflect the intentions of the government stated in 2019. So what was the motivation? From 2 years and 9 months from that commitment to put this section into the Bill 19. And what would stop taking this out of C-19 to be able to study it on the sides, and as you say, a reform of the employment insurance has been announced. So why not include this appeal board, which does not correspond even to the spirit with what was said, the promises made at the time. So that's my question. Do you have any openness to see that this important question can be the subject of consultations in a proper manner? I'm going to answer in English.
2017 third-party review of the Social Security Tribunal and subsequent consultations with stakeholders, especially worker groups, expressed a strong desire to return to regionally based tripartite decision-making panels for the first level appeals. And that is similar to the previous pre-SST Board of Referees. Through the consultations and the analysis, it was argued that this system would help improve the accountability of decision makers to workers and employers while making the recourse process more compassionate and informal for appellants. The Board of Appeal is intending
Mais ma chère dame,
10 secondes.
Mais pourquoi alors que vous...
So why, if you have people concerned, this is a little bit the opposite of what you're telling us. How can you really, I think what we're saying is we need to have a good dialogue. So I think there has to be true consultations. Thank you very much, Madame Chabot.
Merci, Monsieur Boulouris.
Mr. Boulouris, you have 2.5 minutes. Thank you very much, Mr. Chair. I'm going to take advantage of having the floor to say that this leave with pay, medical leave with pay, I think we've worked hard to get this to happen, so I'm quite satisfied. I'd like to come back to the appeal board. I would like to better know why we're leaving the management to a deputy minister who has a political position as with respect to the appointments for this Board of Appeal. What type of control would the deputy minister have on candidates that would be chosen? Is there not a concern that should be we can see there with respect to this Board of Appeal, that it be in the hands of the minister?
Reporting was based on a need for accountability. It was recognized that under the former Board of Referees model, the accountability was dispersed and vague and was to be strengthened moving forward. The direct reporting relationship of this position to the chairperson of the CAIC of the Commission, who is also the accounting officer for the Commission, would ensure that one individual is ultimately responsible and accountable for both the funding and the day-to-day administration of the Board of Appeal. This ensures accountability to Parliament for the effective functioning of the new Board of Appeal is clearly defined and rests with one person. However, the Commission, as most of you are aware, is made of the chair, of the chairperson of the Commission, as well as the two commissioners. So there would be natural consultation and engagement for all the members of the Commission.
D'accord.
Okay. I think I can follow your logic, but there are concerns that people feel that there could be political interference nonetheless. I have a more concrete question with respect to the website for the Board of Appeal, the future Board of Appeal. The SST website works pretty well, and with respect to Service Canada, that's not the case. It says that it's very difficult to find what you need on that website. 5 seconds. So will you take into consideration are you going to have something that will be simple to use and take into consideration that not everybody has digital competence? Yes, I do think it's important to improve access on the site, both with simple language and simple means. Thank you, Mr. Boulouris.
With the 5-minute round to the official opposition and 5 minutes to the government, I don't have the questioner for. Is it Madame Gladue?
It is I. Thank you so much, Chair, and thank you to the witnesses. I'm going to start with a question similar to Mr. Boulouris. In my riding, we are seeing a lot of people without checks for many months because of the backlogs in EI. Even a single mom on mat leave that didn't have any money for 5 months and lost her house. So what is the government specifically doing to take action to make sure they have the capacity to implement the changes that are proposed here? The question is for Ms. Dean.
I actually, that is not my area of responsibility. I'm training an EI Part 2, so I'll turn the floor over to one of my colleagues who will be better placed. Thank you.
Very good. Whoever can answer that, please.
Annette Casey for EI benefit processing. We do work very closely with our policy colleagues to make sure that we have the resources based on a resource determination model to be able to both forecast and ensure that we have the capacity in our networks to be able to deal with the proposed changes here, which is for our area would be the seasonal workers, and so that has been built into the processes and the proposals that are being brought forward today.
Very good. I'm going to continue then with the line of questioning from my colleague, Mr. Ruff, who wanted to know what is the biggest risk? And we got the answer for section 27, for 26, but for sections 27, 29, and 32 for the people responsible, what is the biggest risk that you see implementing this legislation?
So I can answer, hi there, it's Mona Nandi from Employment Insurance Policy. I can answer for Division 27. I would say that the risk is minimal. What we are proposing is a further one-year extension of the seasonal measure that was part of the Budget 2021 temporary measures, and so that it will extend it to October 2023, and a transitional measure for monies on separation. And so, given that all of EI EI Part 1 is being reviewed as part of the comprehensive consultations on EI, the risk is minimal to the program.
Very good. And clause 29?
Hi, I can speak to that, Zia Prou. So no identified risk to flag at this time, but I would go back to December when C3 was introduced and passed in C3. Some employers did raise the fact that they needed time to implement these changes in their systems and collective agreements. And now these amendments actually bring the coming into effect to December 1st, 2022. This should provide them enough time to, make payroll changes and discuss with unions to adjust their collective agreements.
Very good. And clause 32?
So the risks that we can see are really associated with making sure that we're launching within the timelines, within reasonable timelines. We do not want to see the same challenges that the SST faced back in 2012 when they launched with big backlogs, and we are establishing a process to ensure that we do not face that by transitioning the BOA and the SST within a 1-year period. Otherwise, we are delivering on the commitments that the government has made exactly as it was committed to.
Excellent. Final question is, there were consultations that were done on this legislation. I'm not sure one of you talked about that. Has there been any input to suggest that perhaps the extra days for sickness is in conflict with Quebec's jurisdiction in terms of, the medical aspects there?
I'm wondering if you're talking about paid sick leave. I think this is the question. Right. What Quebec does is actually 2 days of paid leave per year. So 10 days is significantly more generous than what the province of Quebec is providing.
For sure, but they didn't express any concern that the federal government is doing something differently.
Our minister has reached out to his counterparts in different provinces in February, and he's going back to talk to them at the end of June. But people are interested and curious to know how these changes will unfold.
Good.
Thank you.
I think I'm out of time. Thanks.
Gladue. Yes, you're right on time, Madame Gladue. Thank you so much. Now to Mr. Collins to end this grouping for 5 minutes. Mr. Collins.
Thanks, Mr. Chairman, and I'll go right to my questions on Division 32, if I could, under the Social Security Tribunal Reform and the EI Board of Appeal. Questions I have in place are, what legislative changes are being proposed? Can I get a brief summary of that on Division 32?
Yeah, certainly. So the key proposed changes to the legislation include changes to other legislation, the Employment and Social Development Act, as well as Federal Courts Act and the Employment Insurance Act. All the changes are, the big changes include, one, establishing the EI Board of Appeal to replace the Social Security Tribunal, General Division, EI section. The second big change is to define the board membership for decision makers. 3, to eliminate low-value legalistic provisions, including the requirement to apply for leave to appeal EI decisions to the appeal division. In terms of the number 2, which is on the board membership, it is really the biggest change is to bring the tripartite decision-making that I've mentioned earlier, as well as providing appellants the ability to choose whether they would prefer in-person or virtual, obviously pandemic allowing.
Thank you for that brief summary. Mr. Chair, through you, if I could ask, how will the current EI recourse process change? So those might be familiar with the current process. What would the new process look like?
You want me to touch on that one, Ruba?
Mr.
Sure.
Scott?
But I'm not clear if the question is on section 32 or on the EI. Okay.
So
Please.
in essence, the big difference with the Board of Appeal versus the current recourse process, the same level of recourses are still in place. The same number of recourse or levels of recourse are still in place. So somebody who does not get benefits would have the right to request reconsideration. Currently, somebody who was dissatisfied with that decision would appeal that to the Social Security Tribunal General Division for EI, second level being to the Appeal Division. Same thing would be in place with the introduction of the Board of Appeal, simply that recon decision would get appealed to the Board of Appeal, and then the appeal right for a Board of Appeal decision would then be to the SST Appeal Division. So it's a replacement, a one-for-one replacement with all of the additional benefits that Rube has already discussed, the tripartite nature of the new tribunal.
Okay, thank you for that. And why is an EI Board of Appeals Secretariat being established?
So any tribunal has two portions to it. One is the decision makers, the people who actually hear the client's side of the story and renders the decision itself. But then there's the whole administrative side of that. Tribunal or any tribunal will have what's called the registry function. They receive the appeal, they pull the information together, they provide the client with any additional information, they provide the members with support, HR, financial support, or finance support, training, quality reviews, reporting, all of that functionality takes place within the secretariat itself. So there's really two parts to the tribunal: the decision makers, the reporting to the executive head, and then in support of that is the secretariat doing all of the administrative function to put the tribunal in a position where they can actually render those decisions that need to be made.
Great, thank you. And what's the cost of the proposed changes?
I'd have to go back and look at the original. There was this is part 3 of a number of changes that have been made going back to 2019. I can't tell you how much has been spent to date right off the top of my head. I can say that we are within the spending envelope that was originally detailed back in budget 2019.
Okay, and my last question on this is when will the EI Board of Appeal be implemented?
So
Short answer.
The plan is to launch the tribunal based on at a later date that will be established by orders in council.
Thank you. Thank you, Mr. Collins. With that, we'll conclude the first grouping, and I would like to a special thank you to all the witnesses for appearing. I gather it was with some obstacles to appear virtually with us today in the committee, and this important work that the committee is undertaking. So I thank you on behalf of the committee for being available under some trying circumstances in Ottawa. So thank you all. Merci beaucoup. We will suspend for a couple of minutes while we transition to the second grouping. Chair, advise me whenever the second grouping is ready. to the second panel on the study of the subject matter of Part 5, Division 26, 27, 29, and 32 of Bill C-19, an act to implement certain provisions of the budget tabled on in Parliament on April the 7th, 2022. We're appearing virtually. I would advise all witnesses they can speak in the official language of their choice. Interpretation is available with the icon at the bottom of your surface. If you're in the committee room, use translation. If translation fails, please seek my attention and we'll suspend while it's being corrected. I would like to remind the witnesses they have 5 minutes as an opening statement and directed through me as the chair. I would ask you to speak slowly for the benefit of translation services, and I will indicate when your time is running out by simply indicating 10 seconds left. So we will begin with avec Monsieur Bolduc, Fédération.
We're going to begin with Mr. Bolduc from the Fédération des Travailleurs et Travailleuses du Québec. Mr. Bolduc, the floor is yours. Thank you very much. Thank you, Mr. Chair. Ladies and gentlemen, parliamentarians, I would like to thank you. Thank you for welcoming me today to allow me to make comments from my organization with respect to C-19, especially Division 32. The FTQ is the most important, largest union with 40% of the unionized workers in Quebec, 600,000 members, and these are the main force of those people that are on salary in Quebec. And we have members in all sectors of activities in the Quebec labor force in all regions, whether it's in the stores, in public institutions, as well as plants. So many members of the FTQ are also women. So Division 32 in the budget, we feel that it has to do with the appeal of employment insurance. In August 2019, from what the statements made, we expected some good news, but I think this is more of a concern, and it doesn't correspond to what was communicated in 2019. So we're very worried with respect to this reform that is being initiated. And we feel that puts people in a difficult situation. And this has to do with the appeal. It is included in an omnibus bill and there were 5 parts, 32 divisions, as well as appendices. And so this is a reform. We feel that it needs more attention. It should have, there are many different aspects to the bill. And we know that the time is limited, and so there's a real possibility that organizations who are concerned about the reform, they will not be able to have their concerns addressed, and they will not be invited. So we're very concerned about Division 32. We think that it should be dealt with separately with a separate bill, and it should be taken out of this omnibus bill C-19, because we think that this reform needs to be looked at. And it needs to be have deliberate, appropriate deliberations. Also, with respect to the appeal process, there should be provisions of that so that that there be a tripartite aspect to this new board, and that it not depend simply on its new president. This would be an important change, and it would really go against the promise that was made. And we believe that there has to be a link to the Commission of Unemployment Insurance has to have a direct link with respect to accountability to ensure that people are well trained and that they're able to go ahead with their mandate within the appeal systems. And there have to be provisions on this appeal process to be able to give the beneficiaries of employment insurance, they need to be able to have regional representation, to be able to have in-person hearings. And as of 2018, we heard about there would be reform, and that those necessary reform had to be based on the client and had to be flexible and accommodating. And this appeal, within here, you have two categories of members. Those are full-time and those that are part-time. This bill should see that all members should be part-times, and that otherwise there may be inequalities and inefficiencies with respect to the distinction between these full-time and part-time members. And those who are full-time are part of the public service, but not to those that are part-time. And so the coordinating members are not the same as those that are part-time. So this is going to create inequitable and unequal sharing of information, and it will not give balance between members of the board. So another element based on this reform, there have to be precisions that would so that the selection of within this board need to if the social partners are not involved in the selection, it will not be fair as respect to the appointment of members. Thank you very much for your attention. Thank you, Mr. Bolduc. Now we're going to move ahead with Mouvement Autonome et Solidaire des Sans-Emploi Réseau Québec. And we have Camille Legault-Touot who will be speaking. Thank you, Mr. Chair. Thank you, ladies and gentlemen, for inviting me today. Our organization defends the right of the unemployed across Quebec in the 10 regions, and to encourage universal access. And we've become aware of Division 32 of Bill C-19, and we want to share our concerns with respect to the appeal process that could be launched this year. What I have to say is similar to what I've already heard today. I don't want to add too much more, but I do want you I want to transmit a certain number of considerations, things that are very important to be able to look at in C-19. So we want to say that we really don't agree with the choice of the government and their intention with respect to this new board with respect to C-19. This is 3 years after announcing the reform, and we feel that nothing has been said for a number of years, and now the government is putting us in front of a fait accompli, and we feel that this will undermine the confidence of the public. Given the situation, the precarious situation of people who are unemployed, who are waiting on a decision from the Board of Appeal, the government must ensure that this new appeal system be simple, be efficient, transparent, and fast. And it has to be adapted to the needs of the unemployed. But with what we've seen on Bill C-19, nothing would indicate that this new Board of Appeal would really represent an improvement for access to justice for the unemployed. And it is not a response to the problems that we've seen at the SST. On the contrary, this new Board of Appeal, in terms of reforming a fragile structure, we feel that this is not going to help the unemployed to be able to defend their rights. And we feel that in terms of the working committee that was set up in 2018, it does not follow through. With respect to the contents on this bill, that look similar to what to what's already mentioned. In its new form, this new council, really, this new board is problematic. We want to say that we need an appeal system that is better adapted to the reality of the unemployed, and that the representative of the unemployed as well as the employers, the members of this board have to be able to understand the particularities of the different regions, the different sectors as well, and there must be in-person representation for hearings, and this would be able to meet the needs, and that needs to be done very quickly. 300 people representing workers, if I've understood, I've heard that there was a number, roughly that number, that were affected. And with respect to the independence of the new Board of Appeal, we should look at this question of independence to see how the management, it would depend on the deputy minister. And we ask, why are we giving this much power in this way? So within this new bill, the role of the commissioners is lessened, and the analysis that we are doing in this form, the commission, this board rather, would need to would only be able to appoint the part-time members. So, and this is as a federation that represent the employers, we feel that you should have that the process appeal needs to have people involved that will be able to represent the unemployed, and they should be able to look at how this board is being set up and how people are members are nominated. And also with respect to accountability, how can the government ensure within that context that exchange between information between the board and the claimants, so those who are appealing? Right now it's a problem. The SST at this point, they can't be. We would like to ask that the reform be dealt with a separate bill, and that this be the Division 32 be removed, because if we move ahead in this fashion, it takes away all possibility to be able to have a greater examination by all of the stakeholders concerned, and we feel that is our point. Thank you very much. Mr. La Liberté, you have the floor for 5 minutes. Thank you, Mr. Chair. My name is Pierre La Liberté. I'm Commissioner for Workers since 2016, so I was present for many of the deliberations that have gone on this issue. And I must say, having followed the evolution of all of this process very closely, that it is very disappointing to be here, and rather than celebrating Division 32 and what it's proposing, it's unfortunately, I'm here to present the concerns I have, rather. And so it's unfortunate, but that's the way it is. So I do appreciate the interventions that have been made earlier, and I think that those interventions can really bring forward the real concerns with respect to this reform. In 2019, when it was announced that there would be a reform and that there would be a study and there would be consultations, and there, I would like to refer to Madame Cousy's comments, who was asking what type of consultation there were. Yes, there were consultations across the country, and it was KPMG that was given that responsibility to go in the field and go ahead with consultation. So I did participate in 7 or 8 meetings at the time, and what KPMG has said it was, they were really said that it was a problem, the SST, and so there was a working group that was set up by the minister with the different interveners, whether the union, whether employers, and to try and come up with a compromise to find something that would work. So the objectives were clear. We wanted to have a quick process that responds to the need of the claimants, and we wanted there to be justice by peers with respect to some members of the community, to have it to be done with in-person hearings, and with the question of costs, if that was central, it was underlying nonetheless, because what we discovered was that the SST, rather than being it was done to create savings, but unfortunately it was exactly the opposite that happened. So right now, a decision of the SST, and it would be much more efficient than 4 years ago. It still costs $4,000 per decision. At the time when there was the three-parted system, it was roughly $700 per decision. So you can do the numbers yourself. You see that even though the objective was to have savings, that was not what the result was. All of the organizations that were involved in this question, of course, I did not find one that would be in agreement with what's being proposed here. My colleague on the employer side, Madam Nancy Philly, with whom I sent a letter to the minister to express our concerns, she also, on her side, went ahead with consultations with her stakeholders, and she noted that also on her end that there were concerns. So all of that brought us to propose withdrawing Division 32 with rather than trying to deal with it there, to take it out and to deal with it properly. So I don't want to go over, how could I put it? I don't want to go through all of the different subjects that have already been brought up, but nonetheless, I would like to speak about a given point, and that's the role of the Commission. You have 16 seconds. Okay, well, maybe I'll stop there. I'll be available to answer your questions. Thank you. Thank you very much, Mr. Laliberté.
The first round with Madame Kuzi. Madame Kuzi, you have the floor for 6 minutes.
Merci, Monsieur le Président, et merci au team.
Thank you, Mr. Chair, and thank you for being here. Mr. Laliberté, I would like to give you the opportunity to end and to conclude your remarks. Well, thank you very much. In fact, what I wanted to note was that the Commission announced a reform, the last reform. It was set aside, and that did not allow us to play our watchdog role, the role that we should play with respect to how the system operates. So when there was dysfunctioning 2013 to 2015, we were a little bit like everyone else to simply be observers without actually being able to do anything. So the management of the SST tightened up since the time, but nonetheless, the Commission has roughly nothing to say. So we feel that that is a problem, and that it's a problem that was recognized by the Minister Jean-Yves Duclos at the time And that was part of the announcement that was made in 2019, that is to bring back the management under their auspices. So even today, we're surprised to see that aspect has been set aside and that we are reducing it to say that it's going to be the president of the commission, but in fact it's the deputy minister. So why circle around the commission? For us, it's really a mystery. And Madame, I've forgotten her name. I'm sorry for mispronouncing her name, but Madame Rubas was saying, Madame Kuzi, one person to decide. Well, I'm sorry, but I think the Commission really could take on that role. Well, thank you very much. I also saw that you made comments with respect to the consultations. So I don't know, Mr. La Liberté, if you have more that you would like to add with respect to consultations that were held. Well, yes, thank you. The consultations, there was something that was very minimal. What we noted was that all of the people were being asked if there was one thing, what should be done? And so unanimously, people would say we have to go back to the old system. The old system was the system of the Board of Referees. And there was also another dimension that I think that was quite important, and that's something that we don't see in Division 32, but it's still important. It's the process of administrative review, reconsideration, where somebody who is appealing would see their file reviewed. In the old days, the system worked in that way. That is, once you opposed, you would go directly to appeal. So within 30 days, you would have a hearing. And the department would do an informal review to decide on the merits of the file. So for a file that would not win before the commission, well, you would change the decision. And where the beneficiary was not right, well, it would go through to the hearing. So that's 30 days. Today, 30 days, you'd be lucky if you had the review done, and then you can start your appeal. And if you're lucky, in 45 days, you'll get a decision. So that's why there are many interveners who have said they would like to go back to the former model where the appeal process was triggered right away, and that forced the department to do a quick review in the interest of all. Because for amounts that are small, it's important for the beneficiary, and to be able to get them 3 or 4 months later, that makes a huge difference. So it's important that the system be fast. Thank you. Thank you, Madame Kuzi.
Oui, merci, Monsieur.
Yes, thank you, Mr. Chair. Thank you to all of our witnesses who are here today. I have heard you speak about the reform and the consultation work that was done for employment insurance. What I would like to hear your opinion on, it would be, first of all, right now we have several divisions that are being studied by our committee. My colleague earlier was referring to the question of medical leave with pay for 10 days and for workers. And I think that there was work that was done to be able to improve the working relationship with the provinces. So I would like to ask, what do you think is worthwhile with what you see before you, and what is the impact of the potential changes that are being presented, especially for the fact that the Quebec and the Quebec government and the federal government will be able to work together for employment insurance and other issues. But also, I would like to know what you have to say about the type of criteria that could be set up for appointments for the governor and councillor to be able to ensure that the Quebec would be represented at the Board of Appeal. So maybe one after the other, you might be able to give us a response. Thank you. Mr. Bolduc, go ahead. Well, I think with respect to the appointments, what's important is that we have people representing the regions. And I heard the government a while back speaking about concerns with respect to representation, with respect to diversity. I'm hearing that less now with respect to appointments. But if there is this concern with respect to appointments, I think that it's important to have diversity. And I think that's important both on the side of workers as well as on the side of the employers. This concern needs to be clear, defined, without necessarily quotas, but I think this concern has to be brought to the forefront so that everyone is available and people take it into consideration. I think that is something that is possible to do. So I wanted to add that on that concern that I've heard in the past, and I've heard less now. Mr. Bolduc, with respect to the negotiations and the work, the interaction with the province of Quebec, do you feel, with respect to what's been presented, do you feel that there has been better collaboration and that people have been communicated with properly? With respect to appointments of the members? No, I'm speaking more about specifically with respect to if we're talking now about wanting to offer leave with pay for medical reasons. Was there consultation with the provinces? And I think that it would be good to let us know. Well, today I was looking especially at Division 32, and so I think that I could answer on to that. Yes, go ahead. Madame Camille, are you still there? Well, as Mr. Bolduc said, I prepared myself. I think we can see that the community groups feel the tripartite process is important. So I think we have to look at the comprehension, and we have to look at getting accessible administrative justice for vulnerable people. I don't know that that has really been understood. And when we hear what's being said today, the idea of separating this out of the bill to be able to ensure that all of the dimensions that would allow the spirit of tripartite process be respected. We don't think it's enough to have representatives of the workers, representative of employers. That's not sufficient. Thank you. Thank you, Madame Martinez. Madame Chabot, you have 6 minutes. Thank you, Mr. Chair. Thank you to the witnesses. And I would like to, everybody spoke about the pandemic and that it was difficult, but with respect to employment insurance, I'd like to really congratulate you for all the work you've done with workers with the unemployed, because within our structure, unemployment or employment insurance is very important. I have a question. We're talking about consultations, and so I would like to ask Mr. Laliberté. You said that you would get consultations. You did confirm that there were a lot of consultations, but I do have a questions. If everybody wants this division to be taken out of the bill, and when we look at the results of the consultation, well, you could say that there weren't any consultations. Those groups that were concerned, that were concerned with what the government was setting up wanted to set up in 2019, where 3 years later we now have an omnibus bill for the budget implementation, but we can't really say that there was consultation, which is the reason that you're asking this to be separated out. Division 32 should be separate, and to go ahead with consultation. What do you think? Mr. Bolduc, Mr. Laliberté. Answer: yes, I do agree with you in the sense that this is a subject that where there's a lot of concern, where I've been working in this field for many years, and here we have a concern with respect to the Board of Appeal, and it's being buried in this omnibus bill, and I think that's going to mean that there's not enough exchange, discussion, and consultation really to really do a proper analysis of the subject. So yes, I know that it may be somewhat difficult to respond to this request, but for the benefit of the situation, I think that it really would be important to take this division out of the bill and to have a specific work done on this subject, which is of great importance for many people. Thank you very much. And so when we look at we said, yes, there were consultations and reports, but when we see what we have before us, well, on that, I don't think there has been consultation. So it's going to be very difficult to work on this in the time frame. So I can understand why you want to take this out of the bill. We have also, this is affecting both the Employment Insurance Act as well as other legislation. So I think that this idea of the tripartite participation is very important, and it's important, therefore, that this appeal process give the beneficiaries of employment insurance the right to have regional representation and to have the possibility of having in-person hearing, which is not in this bill. If I could answer, this issue was one of the key issues, and as Madame Cusi was asking whether there were consultation, well, this was an important key element in the consultation. People wanted to have in-person meetings, to have regional accessibility, and the Minister Duclos at the time said that yes, it's a question of humanizing this administrative apparatus. And so you're right to bring up the fact that there's an absence of specifications here. What we went through with the SST, we don't want to see that again with a new structure which would be independent, to be able to do whatever they want. It would say yes, 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 fine. We have, it's only temporary for the full-time people. Then next year everybody will be part-time, and yes, everything's going to be equally shared. And once you don't have, once things have started, once you have no longer anything to say, well, you're going to be stuck with it. And that's how we were stuck with the SST. The minister had to do an independent inquiry. And you have to remember that, just to be able to know what was happening. This, for me, is an exercise where when we want to take our time to do it properly, I think that's very important to ensure that we're all able to be involved, and also that it corresponds to the objectives that we set ourselves. Thank you, Madame Chabot. Mr. Boulahus.
Merci beaucoup, Monsieur le Président. Je remercie.
Thank you very much for the witnesses that are here today. I have a few questions. My first question is going to be to Mr. Bolduc and Madame Legault-Trot. You've both spoken about the rights for the workers to be able to have an in-person hearing before the new appeal board and to have regional representation, not to limit this with respect to costs, transportation costs, and otherwise. So I don't know if you were able to hear people who were speaking in the last hour, but they were saying that this is something that would be on the table as a possibility. Is it a right? I'm a little skeptical. But what you have heard, did it reassure you, or do you still have concern? Mr. Bolduc first, and then Madame Legault-Trot. Answer. Well, as you said, I did not hear the comments earlier, but unless it's in writing, well, of course, we're going to be concerned. People prefer to be able to work regionally. People have to understand what the reality is in the market where they're working. If I'm a seasonal worker, for example, it's not going to be the same thing whether depending on the region of Quebec where you're working. So people have to have particular expertise in the reality of the region when people are going ahead with appeals. So you need to know the market, know the region, and therefore the process, the selection process, should have been conceived based on that type of criteria. Thank you. Madame Legault-Trot? Yes. Well, concerning having in-person hearings, that necessity. Our organization represent the unemployed, and we've been doing that for several years. And one of the things we've noted and is the lack of comprehension and empathy towards the unemployed when they're being dealt with by telephone. Also understanding their limits, the literacy, and the level of comfort that they have, that plays an important role when you talk about the credibility of people who are presenting. So when you have the SST decisions that are based on whether or not the person made a reasonable choice, well, there you have it. So in that type of situation, yes, in that type of circumstance, yes, there you have it. So for the second question, with respect to regional representation, as you know, the reality of seasonal work, it's in the different regions of Quebec, it's very difficult. You can't, in Lac-Saint-Jean, you have forestry. On the north coast, you have processing of fish, fishing, And in those types of situations, what we see is that there is a lack of understanding of the reality of seasonal work, and that does not allow all of the members to be able to evaluate the credibility of those who are asking for supports for employment insurance. Or they may be asking with respect to search for employment, what's their availability. And so with the board, if we're talking about independence of this tripartite board, well, the neutrality is important. It would mean it wouldn't work if the person is from elsewhere and doesn't understand the realities that are in the field, somebody that would have if they were on location. Thank you. I would now, we talk here about these arbitrary boards. Mr. Laliberté, if I've understood this type of boards, was more quick, costless, and so a naive question on my part. Well, why don't we just go back to what did work in the past? Well, that's a great question. I think that question needs to be asked to those who are the architects of the process. Really, since the beginning, and here I'd like to be brutally honest, we feel that though the officials really prefer the status quo. They want to preserve what is in place as much as possible, and what you see here in Bill C-19 reflects that. Whereas what has been heard in the discussions, heard by the minister, was always that everything was on the table. And unfortunately, we have seen that really that there has been a tightening of everything, and we've been directed into a dead end. So, thank you, Mr. Laliberté and Mr. Boulahus.
I'm Gladue for 5 minutes, and we'll end with Madame Martinez Ferrata with 5. Madame Gladue, you have the floor.
Merci, Monsieur le Président, et merci.
Thank you, Mr. Chair. Thank you to the witnesses. My first question is for Madame Legault-Tuot. Did the government create a problem when the federal government employees got 10 days when they're sick, and elsewhere, everywhere else, they only had 2 days? Well, truthfully, this is something that's beyond my expertise. So our group, we're dealing with the rights of the unemployed, and I don't have expertise in the question you're asking. Okay, well, my second question would be for Mr. Bolduc. You spoke about the fact that you preferred to have provisions for a tripartite consultation process. Could you explain that a little bit more? I'm not sure that I understood the question.
Preferring a tripartite approach. And so I was wondering if you could explain a little more for the appeals that are coming forward, why what we have in this bill is not going to deliver the benefits of that.
Well, one element I could bring forward, well, I think I'd like to understand why the government wants to have the deputy minister as the responsible person for this Board of Appeal. I don't see the advantage there. I think that the signal that the government needs to give with respect to the independence of this board would be much improved if it would be the tripartite commission that would be responsible, where there's the interests of the three different parties, the workers, employers, and so I think it would be important that the board would be accountable to the commission, and that would give a much better general impression with respect to the question of interference, political interference. Thank you very much. Mr. La Liberté.
I mean, what it looks like to me, we have a system that's proposed that will not give independence, right? The deputy minister is going to have, some views that may not be impartial. And at the same time, we've increased the cost for the appeal. Do you have some further comments on this?
Well, there's a lot to be talked about there. I mean, first on I think what was said on the commission versus the commission chair, I think is correct, and I think there is a clash of philosophy. I think sometimes when we deal with the civil service, if you will. I mean that somehow centralizing decision making, and having one person but an expert in the room is better than have like all the stakeholders, so to speak, or people that have, I would say, a different but probably complementary viewpoints on things. That's a different governance model. And I have to say, over the past number of years I've been in this position, I think it's difficult for some people to kind of even get that there's value to this, and so to me, strictly on the notion of governance, and in this case, I mean, I don't need to remind you that we're talking about employer and workers' contribution, right? So at the very basis of the institution is the fact that I mean it's this program is paid for by workers and employers, so they should have a voice.
So they've put their money into it. And so at the end of the day, we've already heard testimony about the capacity issues. And so do you worry that the new model will make, the delays to get an appeal and to get a decision even worse?
Short answer, please.
Well, I have to say that, this isn't a political question in this sense. I mean, I think some extra changes would be needed of the nature I've actually referred to earlier about kicking in the appeal when you contest the file immediately instead of waiting for the recommendation to be. The révision administrative to be done.
Merci, Madame Gladue.
Thank you, Madame Gladue. Madame Martinez-Ferrada. Thank you very much. You have 5 minutes. Yes, I'm going to be sharing time with my colleague. Mr. Long, I would like to come back to Division 32. Earlier, Camille, you were talking about different elements that you felt that were within Division 32 that had been spoken of during the consultations. I would like to come back to maybe you could note which aspects in Division 32 are subjects that were in the consultations. And you also spoke about a system that would be transparent, more efficient, that would be rapid. I'd like to also come back to that issue also. Yes, with respect to your first question, in the elements that the bill is offering right now, the elements are with respect to the tripartite aspect as well as the presidency. And so I'd like to remind you that within the elements earlier where we were talking about why it took so long for the government to act and why they didn't really speak with the people who are using this appeal system. And now our group is seeing that there's a lot of work dealing with the SST, and there have been improvements, and those should be integrated into the appeal process. I'm thinking about all of the process of simplifying things to be able to make sure that the information is much more accessible and that the forms are easier to fill out and that there's communication with the unemployed to give them the information. So improvements that when we look at the bill now, we feel that there's an intention to start all over again. And this seems to be completely disconnected with the reality in the field, where you want to bring forward improvements that the SST is made possible, and through the consultations. I don't know if that really answers your question. Well, that's fine. I'm going to be sharing my time with Mr. Long, but if you could think about that, and maybe you could submit a written answer. And if you were to amend Division 32, what would be the elements that you would like to see amended? If maybe you could write to us and let us know. Thank you very much, Mr. Chair. Mr. Long now has the floor.
Thank you, Chair, and good afternoon again to everybody, and thank you so much to our witnesses that have just testified. I'll throw this question out to anybody that wants to grab it, just for the committee's knowledge. I'm looking for you to elaborate more on how federal paid sick leave requirements and regulations will put pressure on non-federally regulated businesses and provincially regulated sectors to do more on their end to improve workers and benefits. Can you comment on that, please?
Who do you want to direct it to, Mr. Long?
Doesn't matter. Mr. Bolduc?
Mr. Bolduc?
Oui.
Yes. I understood in your question that there was a concern with respect to paid sick leave. When it was a 10-day, so I wasn't, my sound wasn't very good for me to hear the interpretation. So I really prepared based specifically to Division 32 and the Board of Appeals. So I really didn't look at all of the contents of the whole thing. It's a huge bill, and I was mentioning that in my opening remarks. So I think that's really the good reason to withdraw the Division 32 from this omnibus bill, to be able to specifically deal with all of these questions. So I'm sorry to have to give you that answer. Thank you, Mr. Bolduc.
Bye. At this time, I would like to thank all the witnesses for appearing before the committee today and sharing your expertise in your various fields. Is it the pleasure of the committee to adjourn? Seeing no dissent, the committee is adjourned until Thursday. Thank you. Merci beaucoup, tout le monde.